I've lost count of the number of times I've heard this dialogue from a husband client. We are in the middle of a dispute, cases are going on. The husband client comes to my office, tells me, "Sir, the wife has finally agreed for a peaceful mutual divorce. We can finish off all the cases. The amount fixed is XYZ, which is very good for me. I don't mind it at all. But the wife says that if this compromise has to be signed, it must be signed today, maximum by tomorrow, and it must be signed in the lawyer's offices immediately. This is the draft that the wife has sent. Please have a look. Let's execute it immediately." And I always tell husband clients when they tell me all this is that I just want one more small few hour long step added to this process, and then I have absolutely no problem, which is that in the cases, any of the cases going on between the parties, let's institute an application in any of these cases for referring the matter to mediation, because in the mediation cell, then both parties can, whatever document is being signed, after the stamp of the mediation center, neither of the parties can back off of this agreement, because a lot of times I've seen, especially because these settlement agreements are structured in such a way that they stand to benefit the wife very quickly after signing of this document. Say, for example, on the date of signing of this document, the wife will be paid X amount of money. On the date of first motion, the wife will be paid Y amount of money, and the final balance, usually 10 to 20% balance amount, will be paid at the culmination of the proceedings. What happens is a lot of times the wife takes the initial benefit, especially because this document is not signed before the mediation center. You've signed it, you've gotten it notarized, the lawyers have signed as witnesses or whatever. This document will not hold in a court of law when you say, "Look, my wife has already taken the benefit." Instead, this small step, now wives come and say, "This is going to take a lot of time. I can't wait for this. If you're going to wait, let's go back into litigation." And the husband gets afraid. But you need to understand this is often a trick. When I am saying, let's go get it referred to mediation, what do I mean? The matter is ongoing. The next date is maybe 2 months from now. That doesn't mean that the next date you can move this application for referring the matter to mediation. Tomorrow itself, I move an application before the concerned family court, magistrate court, whatever it is. Parties are in settlement talks. Please refer the matter to mediation. You mention the matter to the judge. You tell the judge, please get it listed before the mediation center today for 12 p.m. itself. We've done it in dozens of cases. And when the matter is immediately sent to the mediation cell, you tell them, this is the draft that we've already prepared. Just let's sign it and get you stamped. Within 1-2 hours, we've gotten, 10 a.m. we moved this application before the judge. At 1 p.m., right, 3-4 hours later, that compromise deed is now stamped with the sanctity of the court. It operates as a court decree. If the wife backs out after taking money, the court will still finish off any proceedings pending against the husband if the wife refuses to sign on withdrawal or say for quashing. So you're very, very safe, even if you have to give a little bit of money according to these structured compromise agreements. And if the wife is insisting, "No, we will do this outside," you should be able to understand what are the nefarious intentions at play.